everybody. Welcome back to True Crime Paranormal with the Psychic Sisters. I'm Christy Brower here with my sister, co host, and partner in crime, Katie Weaver. We are back from the lunch break here on the live stream of the change of venue hearing for Chad Daybell.
Yeah.
And we are just waiting for court to come back online.
Yep.
Sorry I missed the very end of the last live stream. I was blissfully sitting in my kitchen and my phone was not alerting me that we were back to live. So I have no idea what was going on.
Yep. You were a little busy.
Not really. I had some lunch. I don't know. I'm not sure what happened. I had my phone on. I had the live stream up on my phone so that I would know when court came back up, and yeah, it didn't.
Look what you did. Look what you did, you little jerk.
I know. Well, thank you for saving my bacon there.
Well, it's okay. I was a little busy on the break finding that clip from Ironwood Insights.
Oh, yes.
And so I posted it. I'm going to put a link here too, but you guys can just find it over on our YouTube channel too at True Crime Paranormal. And we'll put it on our podcast as well. But if you are interested in finding it, it is called Ironwood Survey of Southeast Idaho Residents. And you can listen to it. It's 3 minutes long.
It's 3 minutes wrong. It's very
3
wrong.
minutes wrong. Yeah. I was just, I was a little preoccupied because I was looking at some super big mad comments we've got on the Cassidy rainwater case.
Oh, we have, huh?
Yeah, apparently some of Tim's friends are coming out to defend him.
Whatever.
Since they've known Tim for a long time, there's no way in hell he had something to do with this, even though he's already admitted to it.
Yeah, he admitted to it to the police and is in jail.
Yeah.
So, yeah.
Yep.
Why slander more of their names? He told the police he helped restrain her.
Yeah.
He said it himself. How's that slander? Oh. And court is returning.
Wow. Look how timely.
All right, I think we've got everyone here. Madam Reporter, are you ready?
Yes, Your Honor.
Okay, we'll go back on the record after the lunch break on this matter. This is the time for a change of venue motion. Case CR 2221-1623, State versus Chad Guy Daybell. Counsel's present and appearing. At the time of the lunch break, we concluded with Mr. Pryor's presentation of evidence. And at this point, Mr. Wood, I understood the state had witnesses to call. Is that correct?
Yes, Your Honor. I'm not seeing them in this room. I don't know if they've been accepted yet.
Okay, who's your first witness are you intending to call?
Len Humphreys.
All right, let's see if he's there.
Need to be logged in right now or wait?
It's like he's having an issue getting connected. Do you know where he's appearing from, Mr. Wood?
I believe his office, but I'm not sure, Your Honor.
Okay. I just wondered if he was there.
He's, oh, there he is.
Good afternoon, Sheriff Humphreys. Can you hear me okay?
Yes, Judge, I can.
Okay, thank you. Wanted to make sure you were properly connected. So, Mr. Wood, you may go ahead and call your first witness then.
And the state calls Sheriff Lynn Humphreys.
All right, Mr. Humphreys, or Sheriff Humphreys, if you'd please raise your right hand, I'll have the clerk administer the oath.
You solemnly swear or affirm the testimony you will give in the pending cause will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Thank you. You can lower your hand, and counsel, you can inquire.
Thank you. Can you state your name for the record?
My name is Len Humphreys,
Can you spell your last name for the record?
Humphreys.
All right, and you said sheriff. Can you give us a little more background on that?
I am the Fremont County Sheriff. This is my 13th year as sheriff here in Fremont County.
Okay. So 13 years as sheriff in Fremont County. How long have you been involved in law enforcement?
Went to work here full time in 1988.
Okay. Today, what I need to ask you about, Sheriff, I want to talk about some of your responsibilities as it relates to the district court. Are you responsible for any actions connected to the district court proceedings and jury trials in your role as sheriff?
Yes, we're responsible for the security of the courts. We provide the bailiff services, security for the courthouse. We run the entries where people go through the magnetometers to make sure that there's no weapons. We're responsible for making sure that defendants are transported to and from court in a safe manner. We are also responsible for making sure the juries are safe, and witnesses that they are taken care of. We provide all of those services through the sheriff's office.
And Judge, in objection to where we may be going, I am concerned that the testimony is going to be focusing more on Mr. Wood's motion to impanel a jury than it is to address any concerns he may have about the change of venue. So I guess in the form of an objection, I'm deeply concerned that we're addressing the other issue and not the issue of how this affects a change of venue.
Well, there's been no question relating to that at this point, so that's premature, but I'll keep that in mind.
Thank you. And Your Honor, I would just note the state hasn't filed a motion to impanel a jury. So Sheriff Humphreys, thank you for going over that. Are you also, you said you're responsible for the defendant's security. Are you responsible for housing the defendants?
Yes, we are.
Okay. And are you familiar with the case of the cases of Chad Daybell and Lori Vallow?
Yes, I am.
And are those defendants under your care and custody?
Chad Daybell in my jail here in Fremont County. Lori is in the Madison County Jail, who contracts with us to house our female inmates.
Okay, thank you. Now, the responsibility to cover court proceedings on crimes occurring in Madison County, does that responsibility exist wherever the case itself goes to trial?
I'm not sure I understand your question.
Okay, I'll rephrase it. I think I said Madison County, I meant Fremont County. So I apologize. If a case is a Fremont County case and a change of venue takes place and if that a case is heard elsewhere, do you still maintain the same responsibilities that you would maintain as if it were in Fremont County?
I believe that is the case, either by providing the staff to take care of it or contracting with the host county, wherever that may be.
Okay. Now, do you have a detectives division?
I'm sorry, once more?
Does the Fremont County Sheriff's Office have a detectives division?
Yes, I have 3.
Okay. And are you aware if they've been involved in the case involving Chad Daybell and Lori Vallow?
Yes, they have been involved.
Okay. I want to talk to you about kind of the monetary and manpower costs that arise if they have to travel outside of Fremont County.
Judge, I can object at this point. We're going into the motion of sequestering a jury and the costs that are associated with that. Mr. Wood can shake his head all he wants, but this is a backdoor way to address issues that I'm not prepared to address in terms of fixed costs. If the court's going to allow Mr. Wood to go into this avenue, then I want to be able to question this witness about all of the costs that are associated with bringing a jury from another county or otherwise, because that's exactly what he's trying to do here.
Well, it's overruled at this point. We'll see where the testimony goes on the issue. Of course, the matter before the court today is whether or not venue should be changed, meaning transfer the location of the trial, and I find this to be relevant testimony, so that's overruled. You can continue, Mr. Wood.
Thank you. If your detectives are subpoenaed to testify outside of your county, what are some of the costs that are associated with complying with that subpoena?
Judge, again, I'm going to renew my objection. This goes to the sequestering a jury and cost as it relates to that.
All right.
Your Honor, I'm not talking about sequestering a jury.
Counsel, yeah, I'm overruling the objection for a third time, Mr. Pryor. This is just in question as it relates to possible change of venue. So continue, Mr. Wood.
Thank you. Sheriff, do you recall the question, or do I need to ask it again?
As I recall, the question was the cost involved when deputies are subpoenaed outside of the county. Those costs would be travel costs, of course, per diem, for meals, lodging, overtime costs, possibly. The additional cost of having the deputies outside of the county means that the calls and work that they would normally be doing, I would have to have covered by other officers or have that work delayed until somebody was clear and able to take care of it.
Okay, so it's your testimony that if you had multiple detectives subpoenaed outside your county for a trial, and especially a lengthy trial, could that cause manpower issues for Fremont County detectives or Fremont County Sheriff's Office?
Yes, it would.
Okay. And is it fair to say that those detectives have more cases than the Vallow Daybell case?
Yes, that is fair.
Yeah. Now, at this time, can you put a dollar amount on how much it will cost Fremont County if your detectives are subpoenaed to testify outside of Fremont County?
Excuse me, Your Honor, I'm getting terrible feedback. I can't.
I'm hearing it too.
Yeah, so am I. I'm not sure where that would be coming from. Maybe Sheriff Humphrey's microphone. I'm not sure.
I believe this is for Mr. Ward.
Yeah, it seems to be happening when I'm speaking part of the time.
Okay, hopefully we can figure out where that's coming from. I wasn't doing it before lunch, so I'm not sure why it would be doing it now.
Okay. Sheriff, do you need me to ask that question again?
Yes, please.
The question was, at this time, can you put a dollar amount on how much it will cost Fremont County if your detectives have to travel outside of Fremont County for if they're subpoenaed to testify at a trial?
The there's no way that I could estimate what those costs would be without knowing where the trial might be held or how long the trial might last.
Okay. We talked about your detectives being subpoenaed and what that would do to the detectives department. What are some other responsibilities you may have to provide in another county if a trial is moved?
I anticipate that the same costs would apply as far as providing security, providing transportation, providing housing for employees, as well as jurors, things like that.
Okay. Is it your opinion that trying these cases in Fremont County would be more economical for the Fremont County Sheriff's Department than having it tried in another county?
Judge, I'm going to object at this point. There hasn't been sufficient foundation to suggest. In fact, this witness said that without sitting down and knowing exactly where it would go, he can't make a determination of what the cost would be. So to allow him to speculate would be completely improper. And at this point, allowing this sheriff to make an assessment without knowing where the county that this thing will be moved to, or the additional costs that might be incurred. And again, I'll renew my objection that this actually goes to Mr. Wood's sequestration of a jury in another county. So if Mr. Humphreys wants to come back and talk then, great. But at this point, allowing him to offer an opinion is highly improper.
Mr. Wood?
Your Honor, I think that the sheriff, first, we're not talking about sequestering a jury right now. That's completely separate than a change of venue and the costs that might be associated with it. In terms of what he can testify to, we've already established that, yes, he cannot give an exact dollar amount. However, I do think as the sheriff, he is qualified to testify about the extra expenses of providing these services outside of his own county.
And Judge, actually, this sheriff mentioned the cost of housing a jury. So he brought it up in his case in chief testimony. So again, there's been no specifics, and basically you're going to elicit an opinion from a guy whose qualifications are he's the sheriff without any factual basis for what that opinion is based on.
All right, well, I can consider the testimony for the weight of what it's worth based on the foundation, but I do find that under both Criminal Rule 21 and Title 19, Chapter 18, which discusses removal of an action before trial, that cost can be a consideration, so I do find it's relevant, and I'll overrule the objection so you can answer, Sheriff Humphreys.
Could you repeat the question, please?
Yes, is it your opinion that trying the Chad Daybell case in Fremont County would be more economical for the Sheriff's Department than having it tried in another county?
I do believe it would be more economical to be tried here, yes.
And why is that?
We don't have the travel costs involved. We don't have the issues of providing services in a trial outside of the county, and also maintaining services that go on while this trial is going, the other services, the other duties that need to be carried out on a day-to-day basis.
Okay. And so just one last question. Do your duties in Fremont County cease if you have to provide those services in another county as well?
They do not cease. Those services still need to be provided here.
Okay. That's all the state has at this time, Your Honor.
All right, thank you, Mr. Pryor. Cross-examination.
And Sheriff Humphreys, could you tell me how many employees you have within the Sheriff Department who are deputized?
Deputized, I have approximately 21 officers right now.
How many of them are involved in the Daybell case?
At least 3 that have been involved in the investigation.
So obviously you understand and would agree with me that you obviously don't want those 3 deputies who are involved in the Daybell case to perform the functions within the department. Would that be fair? In regards to security in regards to transporting Mr. Daybell or otherwise, right?
So the two of those are detectives, and the third is my patrol lieutenant, who was a prior detective and was very involved with this case.
All right, so the question, and if you would answer it, is simply that we don't want those three deputies involved in the day-to-day process of such as transporting witnesses, obviously guarding Mr. Daybell, because the potential for some sort of conflict arises at that point, right?
Yes, that's correct.
So we're down to approximately 17 or 18 deputies, correct?
Yes.
And how many deputies does it require you to maintain the jail on a daily basis?
I have 2 deputies on duty at all times in the jail.
Okay, and for how many in a given shift of 24 hours?
That would be 4 and 5 with the supervisor.
And it requires all 17 to provide appropriate supervision, or are you short manned within the sheriff's department in the jail?
No, we are fully staffed at this time.
Okay, so the question then would be, obviously, if anybody has any connection or any sort of link to the Daybell case, you obviously want to exclude them as part of the as part of participating in the day-to-day activities of dealing with jurors, dealing with witnesses, and that sort of thing, correct?
Yes.
And it would be highly inappropriate for someone who has some sort of involvement, even a minimal amount of involvement, to allow themselves to inject themselves in the case, right?
Correct.
Objection goes beyond the scope.
Well, Judge, he's talking, thank you. So, Sheriff Humphreys, I do have a question for you. I'm looking at a June 11th of 2020 posting on your Facebook account. And on the Facebook account, it shows you retweeting pictures of a fence, some posters of JJ and Tylee. It looks like some pictures of a vigil, and there's some
Objection beyond the scope of the direct.
Judge, it goes to whether or not there's involvement by a police officer involved in this case. I have information that this officer is using his private Facebook account to make postings about this case, and further, that Mr. Wood is giving the thumbs up on these accounts.
So, objection
I
relevant.
think it's relevant.
Okay, the issue, underlying issue on change of venue is potential pretrial publicity or bias or prejudice that's come about to potential jurors because of that. And so as it goes to the underlying issue, I will allow for the line of questioning. But Mr. Pryor, I admonish you as previously, if it gets into anything that's inflammatory, I want to take that up outside of the live stream.
Okay, and I'm going to refrain from getting into terrible specifics about some of the things that you post. But Sheriff Humphreys, quite frankly, how many times on your personal Facebook account did you post information or pictures about Chad Daybell or Lori Vallow?
I don't know what you're looking at. I
don't care what I'm looking at. I'm asking you how many times you posted these things on your Facebook account.
Objection
How many?
argumentative.
That is argumentative, Mr. Pryor. Allow an opportunity to respond before you just jump in like that. So Sheriff Humphreys, if you'd respond and further elicit the question of when you said you don't know what he's talking about, what do you mean by that?
I don't recall having posted or forwarded anything showing that on my Facebook account.
Okay, so you have never posted anything on a Facebook account that shows Len Humphreys?
Objection, he's
In regards
misstating
to
the testimony.
and if I could finish, Mr. Wood, in regards to the Daybell and Vallow case, is that your testimony, Sheriff?
I don't.
Objection asked and answered.
He hasn't
Overruled.
answered.
Go ahead and answer, Sheriff.
I don't recall having posted a forward that you have described.
Okay. So do you have access to your Facebook account, and have you deleted anything since June 11th of 2020? Because I'm looking at a Facebook posting with your name on it, dated June 11th of 2020, and it's your picture, and it's obvious that there are images on there that are regarding the Daybell case. Do you dispute? If I could finish, Mr. Wood, are you
I'll let you
disputing
finish.
that took place?
Your Honor, I'm going to object to the form of the question. I'm going to ask that we go into a breakout room, that Mr. Humphreys be shown this exhibit rather than be browbeaten about something that he doesn't know what Mr. Pryor's talking about.
Do you have a copy of the posting you're concerned about, Mr. Pryor?
I have a copy of several postings, Judge, and if you want to go into a breakout room and have a shared screen, we can discuss all of them.
Well, I think that is appropriate for him to be able to
Okay.
view those versus testifying about them. So
Okay.
in order to avoid inflammatory material being broadcast in this proceeding, we still will be on the record. The court will consider sealing portions of the record if necessary. I'll conduct the further inquiry of the witness in regards to these Facebook posts in the breakout session, which will be still on the record with the court reporter. So Madam Clerk, if you set up the breakout room, we'll do that.
Oh, well, yikes. Pryor is an ass, but Humphreys did do that. I'm looking at the post on Facebook right now.
Okay.
It's a reshare. It was posted initially by someone named Ashley Sear. It's a picture of a poster that she put on her own fence that says, parents have a sacred duty to rear their children in love and righteousness, to provide for their physical and spiritual needs, and to teach them to love and serve one another. That's from a proclamation to the family, which is a Mormon proclamation. And then there is a picture of writing on their sidewalk. And this is like, this house is across the street from the courthouse, from the jail.
Okay. Does it
So-
say JJ and Tylee on it?
Yeah, on the sidewalk, there's a picture that her kids made of sidewalk chalk that says Justice for JJ and Tylee. And then there is the Justice for JJ and Tylee poster on her fence.
Okay.
And then there is a screenshot of the proclamation to the family. And then her comments.
Okay.
And then one person responded to it. But I was just looking at the likes because he says that Wood liked that post. So I was just searching through the likes. I don't see that.
Pryor indicated there's more than one.
Yeah, that's the only one I see, unless there's one for this was on the 11th. This was 2 days after the kids were found.
Right.
And this is the only post regarding JJ and Tylee that I can see on his page.
And it's only vaguely regarding JJ and Tylee because Lynn Humphreys is probably a Mormon.
Mhm.
And that proclamation to the family is a big thing in Mormonism. I mean,
Mhm. I'm having a hard time seeing that this was all that improper.
right.
But
We'll see. I mean, the way that Pryor was behaving, you would have thought he'd, posted a big poster that said, Chad Daybell did it.
now there is a post on January 30th, 2020 that shows up on his wall that he didn't post. He's tagged in it. From, it looks like his nephew.
Okay.
This was, January 30th, 2020. This was like 6 months before the kids were even found.
Right.
And then another post, again, he didn't make this, someone posted on his wall. Just saw Len Humphreys on local Fox News about those missing kids in Rexburg, made my Sunday morning seeing him. But again, he didn't post that.
Well, and it was just him being on the news?
Right.
About it?
Which also, he's been on the news about it prior. What you got to say about that?
Right.
I'm just not seeing how any of this is anything.
Right. Well, Pryor's got to have such a freak out about everything.
Such a dramatic response. Yeah.
Honestly, it wasn't smart. Humphrey shouldn't have shared that. Shouldn't share anything on his own personal social media about this case, but it's pretty innocuous.
Well, right. It's hard for me to look at that and think that looks any,
Yeah.
all that inflammatory. Those were literally things that were going on across the street from the courthouse and the jail.
Yeah. Well, and I mean, you're right, cranky, grasping at straws. All of the objecting couldn't even let the sheriff get his words out about the hardship that it would cause. I mean, think about this, you guys. This county has 3 detectives, 3, and 2 of them have investigated this case, which means that if they had to, go somewhere else for a long time to be a part of this trial, that is a big hardship for this county.
Yeah.
Yeah, not the first time a sheriff has done that. Right. It isn't the first time a sheriff has done that.
No.
And I mean, it would be much more inflammatory if he posted his personal opinions about,
Right.
Lori and Chad's guilt or innocence. Like, I think he's taking this way to the extreme.
Oh, you bet he is. However, also Sheriff Humphreys, why do you have an open Facebook page?
Yeah.
He should be locked down on that.
Yeah, it should. That's just that's just trouble waiting to happen, or even why even have one if you are the sheriff of a county.
Yeah, there's that too. So I was just jumping over to the Fremont County Sheriff Facebook page to see if there's anything there that he's going to jump on. But that's literally the only post. I don't know. I mean, to me, that seems,
Yeah.
I don't see anything there, but.
No. As usual, this is a big drama bullshit situation. The way that Pryor's just come out swinging with him,
Oh my
all of
God.
those objections, Wood couldn't even get a question out, nor could Sheriff Humphreys even answer it.
Well, and you could see that the judge had an ass full.
Yeah, he was sick of that.
Yeah.
Well, I mean, come on, he's saying the same thing over and over again. Wood did not ask a single question about sequestering a jury. He was asking about, how does this affect the county?
Yes.
Do you have to go provide all of the security if, he's
Yeah.
taken somewhere else to be
And
tried? What happens with your personnel? Because it is a very large county geographically with a very small police force.
Yeah. Well, and he can't even get the words out in between all of Pryor's yelling and objecting and absolute rudeness.
Yeah. Well, and I used to work domestic violence in this county, and Humphreys was the sheriff at that time as well. He's been the sheriff a long time.
Yeah.
And often I would go to a scene where there was literally only one officer there.
Yeah.
And they wouldn't be able to stay very long because they were the only officer on that night. Because that's what they've got for staff. They don't have very many. And so I'm sure is a hardship if they have to send a bunch of their staff away, pay for them to be put up through all this time and be without them.
Yeah.
So I get where Rob Wood is coming from, that this is a hardship for this county.
Yeah.
Yeah.
Wow.
You'd like to see Pryor get the boot for arrogance. Unfortunately, that is an epidemic in defense attorneys, so probably not going to happen. However, the judge was getting real sick of him with the objections. And Humphreys did say something about a jury, jurors at one point, but Wood didn't ask him that. He just said that.
And I got to tell you, their Facebook page, pictures of, watch out, there's elk on the road in this area. Does anyone know who this mule belongs to?
Yeah.
Someone left their keys at the sand dunes. Are these yours?
Yeah.
Does anyone know whose mule this is? That's too funny.
Yeah. That sounds about right for Fremont County. Yeah, watch out for elk on the road. No kidding.
Oh, has anyone seen this little dog? Someone's missing it. Yeah, this seems like pretty
innocuous.
Pretty hardcore stuff, guys. I don't know. Oh no. Here's someone's emu on the loose.
Oh no. Oh no.
It's two pictures of an emu, and it says, hopefully your day is going better than Deputy Summers. It's not every day you have an emu on the loose. Do you wrestle it, rope it, herd it? Asking for a friend.
That's hilarious, right? What do you do? Because emus, they can kick real hard. You want to be really careful with them.
Right?
They're
Run for
huge.
your life? What do you do?
Yeah.
Oh my God. Pryor was getting way out of hand.
Yeah, he
Way.
was. Well, he wanted to build this up like this was some really big thing. That's
Mhm,
one of the things that Pryor is very good at
mhm.
is ramping up the energy in the hopes that the judge will get caught up in it and see something is bigger than it is. Unfortunately, for him, Judge Boyce just doesn't really seem to take that.
Yeah.
He's a very even keel person.
Yeah. All right. I've scrolled all the way back to June 13th, 2020, where they did share a Rexburg Police Department press release about the finding of the kids.
Okay.
That's public knowledge.
Yeah. Right. Tara says, seriously, I don't remember what I posted in 2020. This is a stretch. It is.
Mhm.
It is. Clearly, it wasn't of extreme importance to Sheriff Humphreys because he didn't
Mhm.
remember it. And then when people tag him in things, I mean, he's not in control of that. He could
Yeah.
have untagged himself, but like he didn't make that.
No, and he's old.
Yeah.
He doesn't know how to untag himself. You know, this is a police officer, not a tech genius. Okay.
Right.
Then on June 11th, they said, we live in an awesome place. We just want to thank everyone who has checked in on our staff, brought snacks, lunches, and shown support. There are too many people and businesses to list, but know that we truly appreciate it so very much. Because the community is trying to take care of the first responders that found,
Dead
buried
kids.
children. Yeah.
Yeah. Yeah. There, I remember, that there was a lot of concern for the officers that had to be present for that. And when the preliminary hearing for Chad, the police officers and the FBI agents that talked about that all choked up and like it's a traumatic experience for them.
Oh, horrible. Horrible, horrible.
Oh, we're back.
Your Honor, I just received a message from Mr. Wood that he's tried re-entering, and it sounds like maybe he wasn't able to get back in.
Okay, we'll give him a few minutes and hopefully when he logs back in, it'll
It
resolve.
looks like he's coming in now.
Okay, thank you. All right, hopefully the feedback issues resolved. You just want to say something, Mr. Wood, to test that out?
Checking. I'm not hearing any feedback now.
Yeah, I think it's better. So thanks for doing that. All right, at this point, Mr. Pryor, then you can continue your cross-examination of Sheriff Humphreys.
And Sheriff Humphreys, after we had an opportunity to go in the break room and you had a look at the Facebook posting, you will acknowledge that on your personal Facebook account on June 11th of 2020, you posted images and a story about the Chad Daybell Lori Vallow case. Is that true?
I did on that date, yes.
Okay. Do you have any recollection, sir, of any other dates that you may have put on your personal Facebook account, images or stories about Chad Daybell and Lori Vallow?
I do not have any recollection of any others.
Is it possible there are others out there?
I don't believe so. I didn't remember having done this one, but I recognize it.
Okay. And this wasn't on the sheriff's website that this was posted on Facebook, was it?
That's correct.
This was on your personal website, correct? A personal Facebook account, correct?
That's correct.
How many followers do you have, sir?
I have no idea.
Okay, thousands?
I don't think so.
Okay, but you would agree with me as the sheriff of Fremont County, you have probably a significant following within the confines of Fremont County. Would you not agree with that?
Objection calls for speculation.
It calls for him to answer a question about his following in Fremont County.
The objection's overruled. And counsel, for both of you, if you make an objection, give me an opportunity to respond first. I may make a ruling without jumping in to counter that, or I may ask for additional input. So with that in mind, the objection's overruled. You can answer, Sheriff Humphreys.
I don't know how many people follow my Facebook page.
Okay. Well, you agree with me that you know how Facebook works. You send an image out to the people who follow you. And not only does it go to the people that follow you, it goes to the people that are on their accounts as well. Does it not?
I couldn't answer as to how Facebook is that way.
Are you aware that you and Mr. Wood are friends on Facebook?
I was not aware of that, no.
Okay. Do you dispute that you and Mr. Wood are friends on Facebook?
I don't know who all is listed as friends on my Facebook page. I don't spend very much time on there.
But you would agree with me that a sheriff who's involved in one of the biggest cases in the country on his personal Facebook account starts posting images as it relates to an investigation in his county. At the least, you would call that questionable conduct, wouldn't you, sir?
Objection calls for speculation.
Overruled on those grounds.
You would call that questionable conduct, wouldn't you, sir?
Objection argumentative.
Judge, you already ruled on it.
Well, that's sustained. It is argumentative.
Okay.
The questionable conduct also does not provide any guidance for the court.
Okay. So is it your position, Sheriff Humphreys, that since you did do some postings and have commented on the Daybell case on your personal account, that you should be excluded in participating in decisions regarding Chad Daybell and his trial?
I make very few decisions regarding his trial.
Well, you posted something on your personal Facebook account about the case, sir, and you acknowledge that you did it. And at this point, you're telling me there's nothing else out there. That's yet to be seen. But at this point, don't you find it inappropriate that a sheriff investigating a criminal case of some notoriety is putting personal postings about the case on his Facebook to some of his friends within Fremont County? You don't see that as a problem, sir?
Objection relevance beyond the scope improper arguments. Argumentative.
Judge, it's actually proper. It goes to bias of this sheriff. He's posting things on his Facebook account and he's sitting there and saying, well, go ahead, Judge, I'm sorry.
Well, law enforcement typically can be biased when they're investigating cases. That's not grounds for this line of questioning. He's a law enforcement officer. It's a personal account. It wasn't posted on the sheriff's official website. The impact that may have on the issue of change of venue is all that the court's concerned about at this point. And I do find the line of questioning improper at this point, and I'm sustaining that objection by Mr. Wood. If you want to get to the relevance of how many people this may have affected in a potential jury pool, that's what the court's concerned with today, Mr. Pryor.
Right. And that's where I'm going, Judge, is that in Fremont County, you would agree with me, Sheriff Humphreys, that Fremont County is a relatively rural county. Would you agree with that?
That's correct.
And you would agree with me that there's been a significant, in fact, a great amount of press coverage as it relates to this case, correct?
There has been.
And you would agree with me that the press coverage in Fremont County alone has been saturated with a variety of photos, videos, stories from East Idaho News and others, correct?
Numerous outlets.
Right. And you would agree in this small rural community with that amount of significant press coverage and a sheriff who's the county sheriff in that, you don't think that you posting things about the Vallow Daybell case has an impact on some of the citizens of Fremont County, Sheriff?
I don't know what impact would be I do not know what impact that would have.
Okay, but you would agree there'd be an impact, right?
There could be.
Okay, and you would agree that it was probably a bad choice to post things about Chad Daybell and Lori Vallow on your Facebook account. You'd agree with that, right?
I do agree with that.
Okay, so in other words, you were at least, and Sheriff, I don't want to berate you and beat you up, but it's not the point here, but what I'm concerned about is that Mr. Vallow or Miss Vallow and Mr. Daybell get a fair opportunity. And you would agree with me that the amount of publicity has been significant. And as the sheriff of this county, contributing to that, however it's gauged, only adds to the media attention and the postings that are increasing the amount of attention brought to this case in Fremont County. You'd agree with that, right?
Objection calls for speculation.
Overruled.
You
If
would
you
agree
can-
with that, Sheriff, correct?
I should not have done it. Yeah, correct.
Okay. And in all likelihood, your posting could have been a factor in at least swaying some people in Fremont County. We don't know how significant. It could be greatly significant, or it could be de minimis. You'd agree with that, right?
Objection calls for speculation.
That's sustained.
Okay. But obviously there was an impact by your actions by putting that on your Facebook account, right?
Objection calls for speculation.
Well, it's asked and answered, so move on to another question, Ms. Pryor.
No, I think that's it, Judge. I'm fine. Thank you.
No more questions for the
No
witness
more
then?
questions, Judge. Thank you.
All right, thank you. That'll conclude the cross-examination. Any redirect, Mr. Wood?
Just one moment, Your Honor. Just one. Sheriff Humphreys, in the post that you saw, did you mention Lori Daybell or Chad Daybell?
I forwarded a post that I saw that
Well, just answer the question. Did you use the names Lori Daybell or Chad Daybell?
no.
Okay, that's all I have, Your Honor.
All right. And with that, that'll conclude the testimony of Sheriff Humphreys. Thanks for your appearance today. You can be excused. And Mr. Wood, if you have another witness, you can call them at this time.
Your Honor, the state calls Shane Turman.
The post that I saw that
Is his last name Turner or Thurman?
Turman.
And how's that
I'll have him
spelled?
spell it.
Okay,
That's showing up as Turner. I'm not sure why.
okay. So it's Turman?
Yes.
All right, Mr. Turman, if you can unmute, please, and if you can get a video signal. There we go. If you would unmute your microphone, please.
Is that?
Okay, I do hear you. Not real loud. I think you might want to talk into your microphone for the questioning. Let me first ask you, is that the correct spelling of your name is listed on the screen there?
Yes, That's correct.
All right, thank you, Officer Turman. At this point then, Mr. Wood, if you'd like to call that witness.
Thank you. Mr. Turman, can you state
Oh.
your name and
He needs
spell
to
it
be
for the
placed,
record?
sorry, he needs to be placed under oath as well before. So, Officer Turman, if you'd please raise your right hand, I'll have Madam Clerk place you under oath.
You solemnly swear or affirm the testimony you will give in the pending cause will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Okay, thank you. You can inquire, Mr. Wood.
Thank you. Can you state your name for the record and spell your last name?
It's Shane Turman. Spelling of my last name is Turman.
Thank you. And what's your title?
I'm the Chief of Police for the city of Rexburg in the state of Idaho.
Okay. How long have you been the chief of the Rexburg Police?
10 years, and this December will be 11 years.
Okay. And how long have you worked for the Rexburg Police Department?
Approximately 33 years.
Okay. Have you ever served as a detective?
Yes, I have.
Okay. Are you familiar with the case regarding Lori Vallow Daybell and Chad Daybell?
Yes.
How have you been involved in that case?
Well, as a chief of police, I've known that it's been going on. My detectives that work here have been some of the key detectives in this case. And so as the chief of police, I've had to make funds available and see to their needs and staffing so that they could perform their duties in this investigation.
Okay. And so have you worked with your detectives and their involvement in this case?
Just getting updates from them. But I
Okay.
have investigation myself.
Okay, so you haven't investigated it, but what has your detectives division's involvement been in this case?
They've been involved in this case from basically day one. I believe it was starting November 1st of 2019 when we received a phone call from a detective in Gilbert, Arizona, asking us to look for a Jeep they believed that was involved in a possible crime down there.
Okay. And let me go back for just a second. How many detectives do you have in your detectives division?
I have 6.
Okay. And is that the current number?
That is the current number.
Okay. Have you had any detectives that have worked on this case that have since retired?
Yes, I've had one detective that I've had 2 detectives retire since this case started, but one of them was really the only one that was working on it out of those 2.
Okay. And as the chief, are you aware that the detectives who've worked on that case could be subpoenaed as witnesses to testify at trial?
Yes, I'm aware of that.
Okay. And I just want to ask you a few questions about if a change of venue in this case is granted and the trial is moved, what kind of cost does the Rexburg Police Department incur as a result of that?
Well, for instance, if we go to the city has a scale for per diem, and so we would have to pay per diem for each one of those detectives, along with depending on how far out it was. If it was a place where we'd have to get them a hotel room, we'd have to get each one of them a room. And for the city, roughly, it's about $71 a day per diem, going off of someplace like Boise, Ada County, most places.
Does that per diem amount change depending on where the location is?
It can, but the 71 is pretty close to most of the places in the state of Idaho.
Okay. So you mentioned per diem costs, you mentioned hotel costs. Are you responsible for their travel costs?
Yes. So we would pay for a hotel room for each one of those detectives plus their per diem.
Okay. Chief, of the detectives you have now, do you know how many of them have been significantly involved in the Vallow Daybell case?
Yes, I have 5 out of my 6 detectives that have been significantly involved.
Okay. And in the event they were subpoenaed for trial, and we don't know how long the trial would last, but I think we can assume it would last several weeks. What effect would that have on your detectives division in Rexburg?
Well, you know, the number one thing as the chief I'm responsible for is the protection of our citizens here. And, you know, as you know, we have a college with 22,000 students. And each one of those detectives is carrying a caseload, dealing with all kinds of different crimes. It would really hinder us because I'd only have one detective that would be available to handle all that. Our detectives are trained, highly trained, in fact, in things that a lot of our patrol officers aren't trained in. And so, you know, for instance, interview and interrogation and things like that. And, you know, right now, a lot of our cases that our detectives are dealing with deal with child abuse, sexual assault type cases. There's some major cases as well.
I'm going to object at this point. We're getting a little off the mark in terms of the dissertation.
Well, it's objections overruled, but I would ask you to keep the questioning in line with the scope of this hearing, Mr. Wood.
Okay. So Chief, just to make sure we understood what you were saying, is it your testimony that it would cause a hardship for the detectives department if they were subpoenaed for a significant amount of time out of their jurisdiction?
Absolutely.
Okay. Are you aware, does the Rexburg City Police Department work with and coordinate with other law enforcement agencies in the area?
Yeah, we work with Fremont County, Madison County, Jefferson, Bonneville. We're on a critical incident task force, so we help our detectives go to those critical incident task force clear down to Pocatello at times, as well as helping on other cases when we're called upon.
Okay, thank you. The state has no further questions at this time.
All right, cross-examination, Mr. Pryor.
So how would I address you, officer? Would I address you as sheriff, or what would be your police
chief of police?
All right, I want to show due respect. Chief, with all of these agreements with the other counties, we're assuming, aren't we, that all 5 of your detectives will be testifying at the same time, right?
I don't know.
Right.
Yeah, I'm guessing they wouldn't all be testifying at the same time.
Okay.
When would they be called up? I don't know.
Okay, well, if one of them were called one day and then went back home, and the other one was called a different day and then went back home, and then another one was called on a third or fourth day and went back home, and a fifth one was called on a day and went back home, is it possible that you could get help from Bonneville, Jefferson, Madison County, Fremont County, for each of those 1 days for an additional law enforcement officer to help you while the one officer is testifying, or even 2? That's possible, isn't it?
Well, it's not as easy as that. It's not like I can call in one of the other detectives to come in and handle one of my officers' cases that they're working on.
Well, it may not be working on the cases, but if there's necessity that there's some patrolling or other things to do, it's not going to impact a case if a detective is taking a few hours off from a case and has to take a day off and then work on the case the next day. You'd agree with that, right?
Yeah, if I was just missing one detective for a day.
So spacing them out or accommodating your schedule with your detectives so it doesn't have an impact, that's something that's a viable alternative, isn't it?
It would depend on how far they've got to travel.
Okay, all right. Now, I'm a little concerned. Obviously, you have detectives that are within your organization that are involved in this case, right?
That is correct.
And they obviously can't be concerned with providing security for Ms. Vallow. She's in the Rexburg. Is she in Madison County, or is she under your supervision with Rexburg?
Neither her or Chad are under our supervision.
They're under Fremont, but they're housed in Madison. Well, not anymore, is she? So I guess my question is this. Well, Judge, I'll draw back on that. I'm gonna save that for a later day. I don't think I have any more questions, Judge. Thank you.
All right, any redirect, Mr. Wood?
Not at this time, Your Honor. No.
Okay, thanks, Chief Terman. That'll conclude your testimony then. Thank you for your appearance this afternoon.
Thank you, Your Honor.
You're welcome. You can log off of the call. Mr. Wood, do you have another witness to call?
No, the state has no other witnesses.
All right. Does either side have any additional evidence or witnesses to call before we get to the argument section of this hearing? Mr. Pryor, starting with you.
Judge, I would just have argument.
All right, Mr. Wood.
No further witnesses.
Okay, we'll consider the evidence presented then. At this point, I will allow argument. It's your motion, Mr. Pryor. If you'd like to make argument, and then hear from Mr. Wood after that.
All right, Judge, I would start out, and we're cutting out a little bit, so my hope is that the court can hear me still. Okay, thank you. Judge, I would start out, but I want to cite the case of Irvin versus Dowd. And the case is 366 US 717. And it's a case that I think is directly on point as it relates to a change of venue. This is a rural community, and the case of Irvin versus Dowd talks about the inherent prejudice when you have a very small rural community. And I think in the Irvin versus Dowd case, they were talking about something that's probably 5 or 6 times bigger than St. Anthony. But in that particular case, Judge, they talked about the prejudice that's inherent when there is such media saturation to such an extent that everybody knows about the case, everybody knows about what's going on in the case, and that the very nature of that excessive and unrelenting publicity causes an inherent prejudice for a defendant to get a fair trial. And I would ask the court to take a look at the Irvin versus Dowd, because the Supreme Court of the United States has set forth criteria, and it's very specific criteria. It's very specific criteria that addresses under what circumstances does a barrage of publications and information cause this inherent prejudice. I would also like the court to look at it's Riddell versus Louisiana, 373 US 723. Again, it talks about how excessive press coverage causes and deprives a defendant of a fair trial. Now, my concern is this, is obviously in the small rural community of St. Anthony, we have had a tremendous amount of attention brought to this. That attention includes a number of pictures, obviously, on East Idaho News. Those pictures include a decoration of the county courthouse. Now, those decorations of the county courthouse in Fremont County, they came down after I made my bond reduction for Mr. Daybell well over a year ago. And it was only after I made that argument did that come down. Then the pictures on East Idaho News talked about the sign that was on the very front when you drive into St. Anthony. There's a sign in the very front of the city that you drive into, and on that sign, and for many, many months, Judge, and you'll look at the publications that were submitted to the court, Justice for JJ and Tiley. Now, that is a constant reminder for anyone who drives into St. Anthony and sees the publicity that is being presented. Now, again, right after the Daybell bond reduction motion, strangely enough, excuse me, that sign came down. The signs and the advertising at the Madison County Courthouse, and there's pictures of that as well. The pictures in Madison County and the ribbons decorating Madison County also came down. My concern, Judge, is that there's been so much publicity, and you're talking about a rural community, and I think Irvin versus Dowd and Riddell versus Louisiana are pertinent and offer some insight in what the court should be looking at in terms of how you make a decision as to whether or not this publicity has reached that level. There's also a case, Judge, and it's United States versus Rewald, R-E-W-A-L-D, 889 Federal 2nd 836 from the Ninth Circuit. It's 1988. Again, that's something else that touches on the issue of what's appropriate in terms of a significant amount of attention. Judge, when I took on the obligation to represent Mr. Daybell in this particular matter, I had no idea that this was going to garner so much attention. I would suggest that, Judge, other than a case that occurred in Minneapolis, this case has drawn more media attention than any other case that I can think of in recent history. It has been incessant. The exhibits that have been admitted, 1 through 8 of my exhibits, they aren't just a couple of pictures, Judge. They are a significant number of videos. They are a significant number of stories. They are a significant number of posts. And it's overwhelming, the amount of attention this case has brought. Now, I'm not going to say what Mr. Wood's argument is, that maybe I haven't shown enough prejudice. Well, I think that if the court reviews Irvin versus Dowd and looks at the cases I cited, you'll see how the United States Supreme Court addresses this issue of incessant, excessive publicity and how it interferes with someone's right to a fair trial. I would submit to the court that the amount of attention has been overwhelming. Now, on August 4th, we had a preliminary hearing. It was the second day of the preliminary hearing. And on August 4th, Court TV, and I believe East Idaho News, published a letter, and I have included it in the submissions, from President Nelson of the Salt Lake City, obviously the president of the LDS Church. And that letter came out on the second day of the Daybell hearing. Now, I've submitted to the court, and I'm not going to go into the details of what was said in that letter, and I will leave it to the court. But what took place afterwards, Judge, were a number of conflicting opinions about people who felt the timing of that letter on August 4th was inappropriate by President Nelson. Now, I have had a wonderful opportunity, if there's any saving grace in me doing this, is that I have jumped into the task of learning as much as I can about the LDS faith. I've tried to teach myself. I've read many of their books. Chad actually provided me one of their books, and I read that. And I did some research on President Nelson. He has done nothing but live an exemplary life. He has been a pillar, and he's been an amazing role model for not only people in the LDS faith, but for people of all faiths. This is a man who has been absolutely exemplary in his conduct. Now, I think that and I'm not going to speak for him, but I think that his motive at that time was to say, listen, let the judicial system play out. The problem is that I don't necessarily agree with maybe his lawyers and the way they drafted that letter, and maybe he needs to look at some other lawyers. But this is not on President Nelson, and I will never disparage him, because everything I've learned about him and read about him is that this is an amazing human being.
Chair, I'm going to object on relevance at this point and facts not in evidence.
Okay.
Well, I'll consider the submission of the latter, but I think we're outside of the scope of this hearing.
Okay.
This
So
language.
I think that what President Nelson was trying to do was he was trying to downplay all the attention for Mr. Daybell in this case, but that submission on the second day of the preliminary hearing brought a lot of attention, and it came directly from the LDS Church, the top of the LDS Church. And again, I don't think President Nelson intended what he did was going to cause that problem, and in fact, I'm almost certain of it. But it did bring a lot of attention. Then sometime later, there was a submission. And this was at the request, and Judge, I've included it as part of the exhibits, and it's in the exhibits. If the court wants the date of when those exhibits were submitted, I believe that was on Fox 13 of August 12th of 2020. That should be in the documents that I provided to you. And what that was a letter from Heather Daybell. And I've included the entire letter as well as the media article that was attached to that. And in that particular letter, Ms. Daybell talked specifics, and she said some very unpleasant things about Mr. Daybell. But the concern I had was this, is that in the letter, she talks immediately, one of the first sentences was, at the request of President Dowling of the Henry Fork stake. And this was also advertised on Court TV. Court TV ran with this story and publicized the entire letter and talked in detail about what was on what Ms. Daybell had said.
Your Honor, I don't want to interrupt Mr. Pryor, but if we are going to be going into these specifics, I'm going to ask that we do it in a breakout room. And he's entitled to argue. I'm just saying if we're going to argue those facts that we've tried to not broadcast, I think that should be done in a breakout.
Judge, and I'm not broadcasting anything. I'm speaking in general, and I'm trying to be as sensitive to everybody as I possibly can.
All right, Mr. Pryor, hold on. There's an objection. I need to make a ruling on that. I am going to sustain that objection in terms that I think it goes beyond the admonishment I've had in terms of the specifics of the exhibits. Those are in the record and will be considered by the court. And I think if you would just refer to those by reference, but without going into the detail in your argument, knowing that those will be considered by the court. So if you'd like to point out or highlight any specific exhibits and how you think those exhibits legally affect this issue, then make argument on that, Mr. Pryor, please.
And Judge, my concern is that's tying my hands in terms of arguing specific facts about these things. But I'll obviously accept the court's admonishment and I'll move forward. So in any event, I would ask the court to take a look at the documents and all of the exhibits that were submitted in regards to Ms. Daybell. I would like the court to take a look at the area that was impacted by Ms. Daybell's letter, and as well as read the article that talks about the scope and the range of where her letter reached and the number of people that it reached. Then we move on, Judge, to the next issue. Now, the next issue is that throughout this proceeding, there have been a number of vigils. Those copies of those articles are included in the documentation that I submitted to the court. There was a vigil, I believe, in Rexburg. There was a vigil that was done in Idaho Falls. My recollection is the one in Idaho Falls brought in several hundred people. I believe there was a vigil in St. Anthony, and there was a vigil in Boise. And the vigil in Boise drew, I believe, 24 people. So it wasn't as well received as the ones over here in Eastern Idaho. But the fact is that there's been the community brought together, and they've had these religious vigils, or however you want to characterize that, in talking about and bringing attention to this case. That obviously brings citizens from all over Eastern Idaho and it draws attention to the case. The next issue, Judge, is we are in a situation, and I'm going to move forward, where we are then having pictures of various businesses in the community selling items of memorabilia. Various citizens in the community, such as a bakery, that in their bakery at a very well-known grocery store in Rexburg are selling cupcakes that have messages that are directly tied to this particular case. And I'm going off, Judge, I apologize, but I'm going off of my slides. My concern is this, is that a combination of the significant amount of media attention, a combination of how the community has brought themselves together to conduct vigils, a combination of letters that have been sent, particularly in the Henry's Fork stake, that have had an impact. And we have no way of knowing when an email is sent out, what's the scope of where that email went to. The combination of people selling memorabilia such as sweatshirts and cupcakes in businesses within Eastern Idaho that directly reference this particular case. A combination of two courthouses in Fremont and Madison County, in which both of those courthouses have put up ribbons around the courthouse that have been posted by East Idaho News. A combination of the number of signs all over the community. Now that's going to have an impact, so I don't see how that's not prejudicial. And when the court looks at Irvin versus Dowd, you will see how the Supreme Court has ruled in that regard. Now, obviously, we're disappointed in the court's ruling as it relates to David Bryant and the survey that was done. But the reality is the results of that survey are disturbing. And the reality is that there has been an incessant amount of attention drawn to this case. And the reality is that what we need to do is get this out of an area where there is such a rural community that has made up their mind, that have, for all practical purposes, Judge, have got on the bandwagon of vigils, merchandising, and a variety of other things. And we need to move it to a place where there's a larger population base. And unfortunately, like many states, there's one large population base, and that's in Boise. And the likelihood is that if we are going to move the case, Boise would be the most obvious place to try to find jurors who either have not made up their mind or have not had a significant amount of attention drawn to this. To suggest that a rural county in eastern Idaho, we can get a fair jury when this thing has been incessantly on the news for almost every day is absolutely ludicrous. And to suggest we can go to Madison County, to suggest we can go to Bonneville County, and if the court decides to move venue and considers Bonneville County, at that point I am going to ask the court to take another look at our survey and apply it as I don't think it's appropriate that anywhere in the 7th Judicial District this thing should be heard. My preference and choice of preferences are simply this, Judge. I would ask the court to consider Boise. I would ask the court to then, if the court did not consider Boise, I would ask for Twin Falls. If Twin Falls is not appropriate to the court, I would ask the court as a third choice to go to Pocatello. At that point, I think that we are far enough away. My final concern is this. I have no doubt that Sheriff Lem Humphreys is a honorable man, and I think he's a good man. I have only had one conversation. I don't even know if Sheriff Humphreys would remember that. We ran across each other on one of the streets in downtown St. Anthony, but I think he made a big mistake, and we all make mistakes. And I think in this instance, Sheriff Humphrey was honorable enough to say, I made a mistake. I posted this on my personal Facebook account, and I advertised that out there with not really thinking through the impact that would have. But the difficulty is when you're the sheriff in a position of authority in a rural community, and you post those things and talk about justice for JJ and Tylee, it cannot help but to have an impact on this community and influence them some way. So in conclusion, Judge, I would ask the court to strongly consider moving this case entirely out of the 7th Judicial District. I think that based on the cases that I presented, based on the 8 folders which contain subfolders of many, many, many documents of a variety of forms, it just doesn't make sense to keep it here. And the difficulty is this, is if the court even considers keeping it in the 7th Judicial District, at that point, David Bryant and his survey should be considered by the court, because at that point we have a survey with legitimate results that says, unfortunately, 82 to 80% have already made up their mind that Mr. Daybell is guilty. This is
I'm not going to object to any comments on the subject of the polls. It's not in evidence.
Okay, and Judge, that's all I have. In Thank you.
All right, and that last reference to the exhibit that was not admitted will not be considered by the court, so I won't consider that part of the argument as well. Thank you for the argument then, Mr. Pryor. Mr. Wood, state's argument.
Thank you, Your Honor. Before I get into the legal argument, just a couple of evidence issues. Mr. Pryor, in his documents that were submitted and admitted, in the metrics folder, there's 2 documents that we'd like to speak about. And I'm more than willing to do that in a breakout room. It's just data, so I don't know that it's objectionable in any way, but I'll leave that to the court's discretion on how we discuss it.
And Judge, I'm not opposed to Mr. Wood bringing up, I'm fully aware of the metrics and East Idaho News' readership as it relates to Boise and Idaho Falls, and I'm happy for Mr. Wood to go into that. I'll be responding though.
Okay, well, if you'd like to, you can, Mr. Wood. That particular exhibit, I don't believe carries any danger of further prejudice, so I think it's fine to review to those metrics or discuss those metrics here on the live stream, Mr. Wood. So if you have any specifics of that you'd like to discuss, go ahead.
So there's 2 documents. They're East Idaho News' user data hits on stories. There's 2 of them. They each have 25 cities. I would note that there is not a single city in Fremont County that shows up in the top 50 cities of hits on East Idaho News Stories. The number one city is Salt Lake City. The second city is Boise. But we're not actually here to talk about Boise or Salt Lake or anywhere else other than Fremont County today. And there's not a city in Fremont County that shows up there. I think that's important. So last week,
I guess part of what we have to look at there too is the population base. I mean, last I checked, I think Fremont County's got about 12,000, around 12,000 people. And, you know, when I look at that list, I guess what I'm getting at is number of hits as a percentage of population. So if you've got a certain number of hits in Boise, but there's 500,000 people in Boise, then Fremont County at 12,000 may not show up. And of course, the concern is the amount as a percentage, I guess, of the citizens that may have been exposed. So I'm just pointing that
Sure.
out. I think a factor that must be considered.
And absolutely, I would point out that there's actually in the most recent census, there's more than 13,000 people. That's not a big difference than 12,000 people, but
Okay.
it is, you know, that's the data. Now, I agree, Your Honor, and quite frankly, some of this data is a little bit murky, but it's still remarkable that in the location of trial, nowhere in Fremont County even shows up in the top 50. And that's all we're submitting that for. As the court noted in the status conference last week, there is a presumption that venue is proper in Fremont County, and that's where the trial should be held. And it's the defense's burden to overcome that presumption. There's two types of prejudice when you're talking about a fair jury in terms of venue. There's actual, which we can't talk about because you have to actually try to pick a jury to get there, or presumed. And at a minimum, the defendant's burden is that he has to show a reasonable likelihood that prejudicial news coverage prevents a fair trial. And in State versus Haddon, it's an Idaho case. The court there recognized that most cases of consequence garner at least some pretrial publicity. However, a presumption of prejudice requiring a change of venue attends only the extreme case. And there's a test for that. And that test remains whether the trial atmosphere has been utterly corrupted by press coverage. Further, State versus Yeager, it is not incumbent upon the trial judge to find jurors who are totally ignorant of the facts and issues involved in this case. Further, in Yeager, publicity by itself does not require a change of venue. An error cannot be predicated on the mere existence of pretrial publicity concerning a criminal case. Now, Mr. Pryor did predict my argument. Yes, the state concedes there's been a lot of pretrial publicity. The state would note that the state has made several attempts to lessen that. We asked that cameras not be allowed in the preliminary hearing, not to seal the hearing, and that's in another case, but it does bear on the publicity of this case. We asked that not be allowed, to simply lessen the amount. And we noted that there's no right to a camera in a courtroom. The Supreme Court's been explicit about that. Mr. Pryor and Mr. Daybell asked that it be shown publicly. So the biggest source of evidence involving this case, Mr. Pryor and Mr. Daybell asked that it be broadcasted to whoever may want to see it, whether that's in Fremont County or outside of the county. So the court has been very clear. There's factors that this court must consider in determining whether or not the defendant has met its burden. The first, the existence of affidavits or indicia of prejudice in the community. Mr. Pryor has not provided one witness to state that they've been prejudiced. He's not provided one affidavit. The case law is replete and talks constantly about providing affidavits to show prejudice. Not one affidavit has been provided. Not one indicia of prejudice has been provided. Not a single witness. The accuracy of the pretrial publicity. Mr. Pryor has not made any attempts whatsoever to show any evidence that the pretrial publicity was inaccurate. He hasn't put on any witnesses to talk about it. He hasn't indicated it himself. There's no showing has been made. The extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence. Again, the defendant is on the burden to show that the general public has been exposed to inflammatory publicity, inaccurate publicity, or publicity based on non-admissible evidence. No such showing has been made. I'll just briefly reference the Heather Daybell email, and I'm not going to get into the facts of it. He can't show how many people received it. He can't show how many people read it. He hasn't produced a single affidavit from anyone saying they were prejudiced by it, nor has he produced a single affidavit of any individual saying they're prejudiced by any of the news. The one area where the number of articles, the state does concede there has been an extreme amount of news surrounding this story. However, the court is clear. That alone does not create a presumption of prejudice.
Mr. Wood, though, on the factors the court does consider, I think, though, the amount in and of itself is certainly a factor, I think, that gets considered. I would note there's a case, State versus Hall, which is an Idaho case, 111-827. And that says impartiality may be affected adversely by the quality or the quantity of pretrial media coverage, and goes on to state that when prospective jurors are incessantly exposed to news stories selectively packaged for mass consumption, they may become subtly conditioned to accept a certain version of facts at trial. Such repetitive exposure may diminish the juror's ability to separate information absorbed before trial from information presented during trial. And that cites to another case, State versus Brooks, 103, Idaho 892. So while there's an argument maybe that the publicity has been accurate, I think just at some point in overwhelming quantity may be something that could lead to that issue discussed in Hall. So I haven't reviewed through all of the exhibits yet to see where we are on that, but I want to let you know that's a concern I do have, is just strictly based on quantity of coverage based on that case.
Well, and it's absolutely within the court's discretion to do so. Like I said, that is one of the factors, is the number of articles. I would just point out, though, that the case law is clear that press coverage itself does not create a presumption of prejudice. But the court is absolutely correct in its discretion to review the number of articles and the substance of them. And that dovetails with whether the potential jurors were so incessantly exposed to such articles that they had subtly become conditioned to accept a particular version of the facts at trial. And I think there's been no showing today, and obviously the court has those items in evidence. It can review those items, and it can make for itself a determination whether or not it's inflammatory, whether or not it's accusatory. I don't know that I've seen a single East Idaho news story that said anyone was guilty or anyone's not entitled to a fair trial. That would be inflammatory. Anyway, I think the court is entitled to absolutely look at that and make that determination. But the facts that have been related are relevant, that the state has seen, and I'll let the court make its own determination, but appear to be true. They're not fortunate facts. They're not good facts. They're not fun. They're disturbing. But accurate representation in the media, absent of showing the prejudice, it should not be enough. And then finally, the length of time elapsed between the pretrial publicity and the trial, and any assurances given by potential jurors themselves concerning their impartiality. This is a little more difficult to look at because we don't have a trial date set. We don't know when trial is going to be, nor do we know what news is going to come in between now and the trial. We don't know if another case is going to come along and blow this one out of the water. We don't know if this case will become the biggest case in the country. So that's difficult for a court to make a determination on that. Again, Your Honor, there is a burden of proof. The defendant is responsible to show a reasonable likelihood that prejudicial news coverage prevents a fair trial. And for that presumption of prejudice, He has to show that this is an extreme case, whether the trial atmosphere has been utterly corrupted by press coverage. I think to get to that point, Your Honor, he has to show some actual prejudice. He has to show, he has to have some witnesses. He has to have some affidavits of people who show prejudice. And he can smile and shake his head no, but that is the burden set out by the case law. And the state will, again, the one thing I do want to point out, there's a lot of talk about the press coverage. There's been nothing that links it just simply to only in Fremont County. It's all over the state. And so I think that's important for the court to consider as well. The hearing today is about Fremont County, and as far as Fremont County is concerned, I don't believe that burden has been met.
All right, thanks for the argument, Mr. Wood. Mr. Pryor, I'll allow you a rebuttal argument if you'd like. Before I do want to address that fact of what's the direct evidence I have about any prejudice within Fremont County itself that's been presented today or that's in the record. And the other issue is, well, not just on that, but why, what would be I know there are some downsides, but why would it not be appropriate to potentially go see if we can get a jury picked? And if that, through the process of voir dire, obviously we can vet out jurors and see where we land. And then if we determine through, instead of the court having to make a determination here based on this, seeing what actually happens when we get enough jurors there to call, why wouldn't we make a try there first before we go through all of what's going to take to move the trial? So those are the two issues I'm thinking about in this decision, if you want to address those.
And Judge, I'll address your first decision about trying to get a jury in Fremont County and then seeing if we're able to do that. The concern, Judge, is in many cases, that's not an unreasonable request. But this isn't any case. This is probably the biggest case in our country right now. And the case involves 6 counts that could cause Mr. Daybell to be given a lethal injection. And what the court is suggesting is that we're going to pick a jury. And oh, by the way, if we're not able to pick a jury out of Fremont County, at that point, then maybe we need to look somewhere else. But the picking of a jury is not just as simple as bringing 100 people in and saying, let's pick 100 people and see if we can find some people to do this. There are going to be, and then obviously the court's going to see these motions, but there are going to be studies. There's going to be questionnaires. There's going to be a lot of effort. And in my past, when I've been involved in significant cases, there have been times when picking a jury has taken a week, has taken 2 weeks. And if the court is going to invest a week or 2 weeks in picking a jury, and then we come to the conclusion that we're not able to pick a jury here, at that point, we then have to find a place to find a jury to pick and go through the 2-week process again. It would seem that's a waste of resources. Mr. Wood seems so concerned about resources that he forgets that this is Mr. Daybell's right to a fair, impartial jury. And even though he's waived a speedy trial, Judge, Mr. Daybell's been locked up for a significant amount of time. If for some reason in several months from now, we're not able to come up with a jury, it's going to be several more months, maybe even longer, before we can get into another jurisdiction where we're going to pick a jury. So the reality of it is this, is that taking a test run and taking a stab to see if we can do it. When you're dealing with a death penalty case, that's not the manner in which you proceed. The manner in which you proceed is you find an appropriate jurisdiction that you know you have the best chance to obtain a fair and impartial jury. And from my position, the largest metropolitan area in the state of Idaho is Boise, the Treasure Valley. Whether that's Ada County, whether that's Canyon County, that's where we are more than likely to find the largest number of people who may not have heard about this or have may not made up their decision. Now, the prejudice and the direct prejudice question, Judge. This court made it very clear, and I had advised the court that I had a slideshow that I was intending to show a number of slides, and I was intending on putting on a significant presentation. This court was not going to allow me to present certain slides and certain evidence. In fact, the court stopped me on the Heather Daybell thing and said, I'm not letting you get into this. Now, isn't that the very definition of inflammatory or influencing? when
Well,
you're,
and to be clear, I'll review that evidence. The evidence is there and you can refer to it and I can look at it for what it is and make that determination. So it was only in expressly relating to it an argument that I curtailed there, Mr. Pryor.
right. And you know, and Judge, if it wasn't so inflammatory, if it wasn't so concerning, we'd be showing it to all the people watching right now. But the reality is there is disconcerting stuff. And Mr. Wood can put in his pleadings, and Mr. Wood, and this is all on the stuff that I submitted, Mr. Wood can do a press conference and announce that he's seeking the death penalty, and Ms. Blake can get on there and speak.
No, Jack, that's a fact, not an evidence, and that never happened.
Well, that's the objection sustained because that's outside of the scope of anything presented at the hearing here, Mr. Pryor.
Well, it's in the evidence, Judge, and it's in the videotapes that have been submitted. So
okay, it's there, then I'll consider it. But
and at that point, Judge, you know what? Mr. Pryor hasn't got on public TV. Mr. Pryor hasn't gone on court TV. Mr. Pryor hasn't gone on Dateline or anything else and done anything like that. But what has happened in Fremont County is Heather Daybell wrote a letter to the Henry's Fork Stake. That letter was disseminated, and the court can read the article about how far it was disseminated. That's a problem for us. That's a problem for a fair trial. And then what did we hear about today? The sheriff of Fremont County in 2020 on his personal Facebook account posted images of the Daybell case. Now, Mr. Wood brought up, well, you didn't mention Chad or Lori. No, he just mentioned Tylee and JJ on it, and then talked about some other things that were posted as part of this. If you're telling me that a sheriff in a county whose job is part to investigate this case and to provide assistance to Mr. Wood gets on his personal Facebook account and advertises out there, you're telling me that that's not going to have an impact? You're telling me that's not going to influence citizens in rural Fremont County? That is absolutely ridiculous to suggest that it wouldn't influence people. Finally, Judge, again, I keep going back to this. Mr. Wood is misconstruing the case law as it relates to venue. Mr. Wood is absolutely misconstruing the case law and what it says. If the media coverage is so great that it inherently is going to influence the outcome or attention brought to this case, that's in case law, that's addressed in the Hall case that the court brought up, but more importantly, Judge, it's addressed in our highest court in the United States, the U.S. Supreme Court. And they have clearly set forth the standards, not the standards Mr. Wood would like you to follow, but the standards that all of us should be following. Judge, I've been doing this for a little north of 25 years. I have never seen a case that has brought on so much attention. I have never seen a case, and the court can go back, and I can't even imagine the task this court has of having to go through all of the evidence that I've submitted. Many, many items of evidence that this court's going to have to sift through, and it's a huge task. It's a monstrous task. It was a monstrous task to go through all of the stuff for me. I can't even imagine. But Judge, if it's that big of a task, that would suggest that the media attention has been significant, more than significant. It's been outrageous. And it's not a coincidence that in Idaho Falls, Idaho, now I don't want to misstate how far St. Anthony is from Idaho Falls, but these folks in this side of the state have their very own news agency, East Idaho News. This is a very prominent news organization. And whether I agree or disagree with everything that they put on there, and obviously I'm not going to make a public statement, but I don't agree with what's been said about Mr. Daybell. In fact, most of it I disagree with. Almost all of it I disagree with. And unfortunately now I broadcast that. But that's not the meter that you go by. You apply the Irvin versus Dowd in the cases I applied. And there is no way that with the amount of tension that Mr. Daybell could get a fair trial here. And the difficulty is, it's not let's like shoot basketball hoops and hope maybe we could sink a few and get a fair jury. We don't get to take a try and say, well, let's take a stab at it. And if it doesn't work, well, we'll move it somewhere else and take another stab. That just doesn't make sense. So I would encourage the court to please, this needs to be in the western part of the state in Boise, Idaho, in Ada County, and that would be the best chance we could get for having a fair and impartial jury.
Okay, Thanks for the argument, counsel.
Your Honor, I
to a little
don't want to
more depth.
re-argue anything.
I was going to say,
I'm gonna
Mr. Wood, if you
object.
have any additional argument, you may.
All I wanted to say, Your Honor, the state just really, the way that Mr. Pryor has discussed Sheriff Humphreys, we strongly disagree with. He hasn't cited any law, any rules of ethics, or anything else that he's done wrong. And the way that he treated him as a witness and the way he spoke, we just strongly disagree with, and we'll leave it at that.
And Judge, if he's going to make a statement, then I want a response. Sheriff Humphreys acknowledged.
No, Mr. Pryor, listen. He testified. I gathered the reason for the testimony. He made his answers. I'll take that under advisement. I don't need further argument to construe what he said or what he did. So I'll consider the matter submitted in terms of both argument and evidence. So the court needs to review through the evidence, obviously, that's submitted today. I'll issue a written decision on the motion to change venue, which, again, to be very clear, does not actually change venue of the case. It's a transfer of trial under Criminal Rule 21 and also under Title 19, Chapter 18 of the Idaho Code. So I will take it under advisement, get a written decision and determination on that, and that will conclude the hearing. Counsel, while that does conclude the hearing, there's one other matter I wanted to take up separately as it relates to a motion that's been sealed. And while I have counsel on the line, I just want to briefly address that. So we will conclude this hearing on the motion. And then if we could just briefly go into a breakout room for a moment with Mr. Pryor and the prosecution and the court reporter, I'll address the issue related to that other motion, and then we'll be in recess for the day on the case. So Madam Clerk, if you'd set that breakout room up, then we will talk further there.
Well,
Now,
okay
Mr.
then.
Pryor, listen.
Right.
We've all had enough of you.
Oh my God. I'm very glad I don't have to listen to any more of him today.
Oh. At some point, his energy makes me really anxious. Just the intensity, my God.
Yeah. Yeah.
His blood pressure must be through the freaking roof.
Oh, it must. But, you know, I mean, seriously, all of this pearl clutching and bitching and moaning about all of the coverage of this case, Chad Daybell had dead children buried in his backyard. If he didn't want a bunch of attention, then maybe you shouldn't have done that. You know, like, give me a friggin' break here.
Yeah. Yeah.
We
Chris,
all
you're
know
correct.
that the reason for the attention was the choices made
Well,
and the crimes committed here.
The
Like,
egregious crimes here. I mean, come on, man. That's not the sheriff's fault. That's not the media's fault. That's nobody's fault.
no,
Yeah.
it isn't.
Except for Chad and Lori's.
Yeah.
Chris said you could try him on Mars. He's still a sick, twisted murderer and will still fry. Well, he will. I mean, that's the thing. It doesn't matter
None of this
what
is gonna
jury
matter
hears
in the
this
end.
case. Yeah.
Yeah.
I agree, Idaho Rebel Girl. I love that Rob defended Sheriff Len Humphreys. Absolutely. Humphreys didn't do anything wrong. Give me a damn break.
Right. Well, and Pryor just kept overblowing it. Well, you've made posts on Facebook. He kept implying there were more, and you know, because you looked at his page, that that's
There are
not true.
more. Well, he tried to indicate maybe there were some that had been deleted.
Oh,
Does that strike you as a guy who deletes shit on Facebook? He barely knows how to use Facebook.
right. He barely
That's not
even knew what he
happening.
had posted. No,
Yeah.
he didn't. And it's not like he posted anything like Chad Daybell is guilty, you know, like, come on.
No. It was, and this is why it was posted, and I wish they could have said this, and I know why they couldn't, but the officers that were involved in finding those kids have been horrifically traumatized.
Right.
It was an awful, awful thing. They are ill inside. They are so broken up. They still are. It's been a horrible thing for them.
Yes.
And that's what Humphreys was feeling, is that he had just looked two dead kids in the face that had been buried and burned and mutilated by these fools. And somebody posted something in kindness about the kids and about the way we treat our children and should treat our children. And he shared it. I mean, that's it. That's it.
All it was. And it's not going to change anything. And whatever,
Well,
I think I think that the judge is gonna come back on Pryor's side and say, yes, we need to move this trial. But I
mhm,
also think it might mean bringing in a jury. I'm not sure it will actually
mhm,
mean physically moving the trial.
Well, I love how he finally threw the gauntlet out for Boise.
Yeah,
He hemmed
because
hawed around
that's
about that
Boise.
for quite a while, but he
Yeah,
finally threw it down that what he really wants is Ada County. And we know that it's not going to just be as easy as saying, okay, we're moving to Ada.
right. Because we have it on good authority that Ada County does not want it, does
Yeah.
not want to take it.
That they don't have the time for it, they don't have the funding for it, they don't have the
Mhm.
energy for it, and that they're planning on
Well,
punting it back and saying we can't do it.
yeah,
Yeah.
exactly. Well, and telling the judge what you do and don't do in a death penalty trial is pretty damn hilarious considering that Pryor's never tried one before.
Yeah.
I thought
Does the
that was
judge
very
travel?
presumptuous.
Yeah. Does the judge travel with the trial? Our understanding is that yes, he does.
Generally, they can opt not to apparently, but most of the time they do.
Mm-hmm. And Rhombohedral, what I don't get is this is a death penalty trial. Pryor can be second chair, but not first. Okay. So what we
He
learned
can.
about that is that because he's still a private pay client, yes, he can. Chad can choose to hire whoever he wants.
Right.
If Chad was found to be indigent and the state started having to pay for his bill, they could say, no, you have to have somebody like they did in Lori's case.
Yes. So Ada County is Boise, which is the uh, capital of the state of Idaho, and it's about 5 hours away from where
Mm-hmm.
we are, from where this trial would be now. So
Mm-hmm.
it's a significant difference. However, it is very close to where Pryor is in Caldwell. So
That's yeah. Caldwell is about 30 minutes outside of Boise. So of course he wants to move it to his house. Yeah.
mhm, yeah. But it is a thing that is done that a jury is sequestered from another county, for example, Ada, and
Mm-hmm.
brought here and put up in a hotel. I mean, that is a possible thing,
Mm-hmm.
and may be more cost effective
Mm-hmm.
because it's only moving the jury and not the entire trial and all of the witnesses and the defendants who would
The
have to be housed in
detectives.
other jails and all that stuff.
Mm-hmm.
So
I
we'll
thought that was
see.
an interesting point about all the detectives that could be pulled, for an
Mhm.
indefinite amount of time. Yeah.
These are small police forces, and so
Yeah.
to lose people for a significant amount of time, depending on how long they would have to be gone, especially in Fremont County. I mean, they have
Mhm.
3 detectives, guys.
Yeah.
You know? What did he say? They have 21 employees deputized, and that includes those that work at the jail.
Yeah.
So, yeah.
Yeah. And yes, Ada County is too backed up because of COVID. Ada County's
Right.
courts are struggling too. Yeah.
Yeah. That's the thing. All of this is all contingent upon when we can even have in-person trials because the state Supreme Court has stopped
Mhm.
them again and for we don't know how long. So
Yeah. Yeah.
they can deputize more. Well, I don't know. The Pryor was just using that term to, you know how he does to make himself sound smart. I think that's just basically how many um, police officers they have in that county.
Mm-hmm.
Yeah.
Yeah. Yeah. So
Whew.
there you go. I don't know. I prior that dude's intense. Man, he's belligerent. We've called proceedings with Means and Prior belligerent turd circuses before, and I think we can all say without a doubt, you will all agree with me, I'm sure, when I say it was
Yeah,
fact
that's
amundo
going on the bingo card.
that was a belligerent turd circus.
It
Holy shit.
certainly was.
How grateful are you that we didn't also have to listen to Mark Means with this
Oh
today?
my
Can
God,
you
this would have
imagine?
gone into the second day. If Means had been
Without
here,
a
this would
doubt.
have gone into the
Yeah.
second day. No
Yeah.
doubt.
Without a doubt. And
Well,
now they still have to come back and argue for sequester.
and then there's the argument to sever the trials, which I think it's pretty clear the judge does not want to do,
Mm-hmm.
again, because of the cost.
Mm-hmm.
So there's still so much more of this crap to come, you guys. Oh my God.
I think it is so bothersome. It really is to me that's like the cost is like paramount. You know, well, what is the cost of justice for the lives of everyone
Right.
that these idiots have killed and or destroyed and affected? What is the cost of justice? I mean, I would love to say it just should be a blank check, and I do believe that to some degree, but God, I hate the fact that so much of this is about, well, that would be an expensive thing to do.
Mm-hmm.
Well, you know,
But these law enforcement agencies and these courts, I mean, they have budgets. They're trying to work within what they have, but they can't predict what crazy crimes may be committed in their communities too.
Yeah.
Yeah, it's a hard thing, but you know, that's why I'm sure there's a hope that these two take a plea.
Yeah.
That
Well,
possibility does arise at some point.
that also means that they may take pleas that, as the public, we don't like. You know, it could be that they end up taking pleas that keep them behind bars forever, but that as a public, we go, that sucks and it's not fair because of this very thing.
We'll see. You know, I mean, I think they're both very unwise to go to court, to go all the way through trial with the death penalty on the table, considering the things that they've done and just what we know of the evidence that's out there that
Because
points
there's
to
so
them
much
having done
more.
it. Yeah, and there's so much more. We don't know what was presented at the grand jury, but it was definitely a lot more.
Yeah.
You know?
Oh, even can you imagine as a juror getting to sit through or having to sit through a slideshow of the crime scene?
No.
You know, those babies being dug up, and I can't even fathom what that will do to a jury.
Well, yeah. I know there's the cost of the trauma of this case for law enforcement, for the courts, for the jury, for the families, you know, it's a cost that can never be fully paid.
No. Yeah, it's true, Chris. If we just let them out of jail for a minute, this would be over.
Yeah, especially living where we do. But then again, where's
we'd
justice?
Be in court again for something else.
Yes. Yeah. So we will be back with a new case that will be breaking tonight, our Wednesday case, and then we will be back tomorrow night with our regular case updates, and we'll be back Thursday night with the Psychic Hour. It is at 8 p.m. Mountain right now, and it will be marching orders for the month of October, which is going to be really fun.
Yep.
Yeah, so we have lots more great programming coming up. Make sure you check out this week's cases so far.
Yeah.
These are some very current active cases. We're covering some really current stuff right now that we want to keep up with, and we will continue to update in our updates.
Yeah. Yep. Yes, Fran. Any way you look at it, there's a cost in every capacity. Yep.
There definitely is. Well, thanks for hanging with us today, you guys. We know it's been long and annoying and frustrating, and I'm sure you'll agree with me on this. We are all tired of listening to John Pryor speak. So y'all go do something nice for yourselves.
Thanks guys. Take care.
Bye.